parent that was pregnant. I usually work little bits of time, often out of state, which is a long story anyways. But I am getting short on money, and I may very well need to take another short-term job before we're planning on moving to Oregon, because I may run out of money and not be able to pay the bills. So I can't do that in trial for 8 to 10 weeks.
All right, I appreciate your explanation from the state and follow-up with our.
Thank you, Your Honor. We also had marked down to talk further with Juror 937 about the listed hardships. I think the court already went over the questions with regard to rescheduling and that kind of information. Given everything from Juror 937, the state would make a motion to remove her for cause for hardship.
All right, from the defense.
Judge, I concur in that motion. I had her marked as hardship.
All right, Juror 937, thank you for your service in completing the questionnaire. I'll sustain the motion of the state without objection of the defense that you stated a sufficient rationale for a hardship preventing your service in this case, given the length of the trial. So Juror 937 may be excused. Please drop your questionnaire off with the bailiff on your way. Next, talk to Juror 1004. All right, raise your card, please.
Yes, sir.
Thank you. In this case, you didn't indicate anything in the questionnaire. Would you please explain what's going on that would create a hardship at this point?
Yes, Your Honor. As far as employment goes, I'd be able to retain that, and I'd be basically be FMLA and a protected pay, so coming out of my pay account or my time I've built up. It would require additional staffing to be called in to fill my position due to the nature of my job. The additional issue would be with childcare and the cost of childcare. My wife's current job that she'd be getting soon would be essentially a 9 to 5 every week for the foreseeable future. And if I was required to attend here, I'd have to provide childcare for a 3-year-old, and then also for my 12-year-old, and my 15-year-old is currently employed, and I help with his mom to take him to and from his current employment as well. So being unavailable to be there for that would create significant issues, again, with child cost, to even find childcare for them. And also, I'm sure their mom would take issue with me not being able to take them on the days that's currently scheduled for me to have them.
All right, you're currently a police officer, is that correct?
Yes, Your Honor.
And are you saying that your department won't, or your employer won't cover jury service?
So I believe they will. I'm not clear. I've discussed with them the potential of needing to be here. I'm a little unclear, and that's entirely on me as far as exactly how that pay would go. I certainly would be compensated. It certainly wouldn't lose my employment. But due to minimum staffing requirements for our department, if I wasn't available, there would be frequently days where other members would have to be called in on their days off to fill my position.
Okay, thank you for the explanations. From the state, Angordar.
Your Honor, I just would like to clarify. I think I understood correctly. The concern sounds like when your wife's at work, you provide the child care?
So I will clarify. So my current wife is the one that's beginning a new job. Her and I have a 3-year-old daughter together. My ex-wife is the one I have my 15-year-old, 12-year-old with, have custody schedule. And I would get them for part of the week, and she gets them for another part of the week. So if I was unavailable, per the agreement, she would be the first one I'd have to ask to cover for that. If she was unavailable, then it'd be a child care issue trying to find care for them. Not so much for my 15-year-old, but getting him to and from his place of employment so he didn't lose his job and just as well. So it'd be a custody potential issue if she wanted to make it, which would be surprised if she did. But then for my current wife, it would be just the cost of finding constant daily long-term care for my year-old.
Because when your current wife starts her new job, you would be providing the child care for the 3-year-old at times at least?
Yes.
Okay, I just wanted to make sure I understood that, and you do not have child care already set up or anyone in place,
So
is that correct?
we do have someone in place. I'm not sure if she's gonna be able to fulfill every single day of the week, during the normal work week. Right now, due to the way our schedules work, she watches my daughters only a couple days a week that we need coverage, just because we've adjusted our schedules to where we actually work opposite sides of the week. And there's only a day or two here and there where we actually need coverage. Other than that, we just switch off with those duties.
Thank you for that additional explanation. I just wanted to make sure I understood correctly. Judge, given all of that, I think it does rise to the level of a hardship, and the state would make a motion to exclude juror 1004.
Mr. Pryor.
Judge, I'd also agree with 204. He speaks to, as a lawyer, I'm well aware of the difficulties with ex-wives and these smart trying to navigate through custody and the impact actually on your 2 teenage children. That has to be taken into consideration. And the fact that the financial burden of having to provide additional child care to your children, I think it's necessary that you be excused. I don't know if we should force him to earn that burden.
All right, I'm considering this one. Juror 1004, in your questionnaire, you indicated that your current wife is also a police officer. Is that correct?
That is correct, sir.
All right. Having considered the challenge here, the court is going to deny the challenge to strike. I don't find that there's a for-cause hardship represented by this prospective juror rising to the level that they would be unable to serve in this case. While I understand that may be hugely inconvenient if the trial really goes as long as we've scheduled, it's an inconvenience for anyone required to sit for that length of time. And based on that, juror number 1004 will remain in for further individual questioning or group questioning. All right, the next hardship issue raised was by juror number 1032. All right, thank you. All right, this juror's requested a hardship excuse in the questionnaire, talking about employee training and employment issues, and also issues with tending to children, including a special ed child. So would you please describe to the court in a little more detail about how this may impact your employment as well as your family issues involving your children?
Yes, so as far as the employment, I verified that I will get paid for at least 6 weeks. We're still rolling that up the chain to make sure that it would go to 8 to 10 weeks. So I'm pretty confident that I would get paid. The inconvenience and hardship would be more family related. My wife and I are the sole providers here. We have no family, no caretakers. I'm the one in the morning that makes breakfast. If the girl's ready, she has to leave the house about 6:45. She's a special ed teacher. To clarify, our kids are not special ed. She is a special ed teacher. For example, the past week when I had to come for jury duty and today, she has to show up to work 3 hours late. It's kind of a ripple effect on her. Our schedules, the different schedules to the 6 and 3 that we have. To add, I sent to that case recently. We just had a family diagnosis of cancer, stage 4, which is out of state, and we've been trying to monitor it. Hopefully it doesn't turn into the worst case scenario, but she may have to travel, depending on the circumstances, in the next 3 or 4 6 weeks. We hope it doesn't get that level, but there is a possibility that she may travel, and if she travels, that kind of leaves me in limbo with the kids, kind of uncertain.
All right, thank you for that explanation. Let me go on to the state then and ask the state if they have any voir dire on the hardship request.
Judge, the state does not have any questions at this time.
All right, Mr. Pryor.
Sir, all of these things, the thought of, I'm sorry about the cancer diagnosis. Yeah. All of these things that you just talked about are going to be distractions for you. That'd be fair.
I think that's fair.
And these distractions, are they going to be in any way impact your ability to listen to the testimony and make a fair and impartial ruling? In this case, is this going to be something that you're going to be thinking about and not focusing on the significant importance of this case?
I think that's safe to say my mind will be wandering on other things, yes.
Judge, based on that, I'm going to move to excuse this juror for cause.
All right, based on those further responses from the state, the response to the motion to strike.
Your Honor, the state has no objection.
All right, given those previous responses, juror number 1032, the court is going to find that service in this case would constitute a hardship, disallowing their service. So I'll sustain that defense motion to strike. And you can be excused with the thanks of the court. Please return your questionnaire to the bailiff on the way out. I believe that concludes discussion of hardship with this group of jurors, and thank you all who are remaining here at this time. The next matter we'll go into.
You approach just briefly.
Yes. All right, we're back on the record. I had a brief sidebar with counsel. On the issue of hardship, we had one other juror that we just wanted to talk to about that, juror 752. Thank you. You did indicate in your questionnaire you believe you had a hardship. We didn't discuss that. I don't see that you raised your card. It was work-related issues. Do you have anything to indicate on that, or have you resolved any potential hardship, and would you be able to serve given the timing?
So I am currently the CFO of the entity that I'm at, and I know everybody has time commitments, hardship and stuff. I do have a stay-at-home wife. I have spoken to the CEO of the company to let him know we're trying to figure out backup plans. I didn't, like say, I didn't feel we could potentially work around it, but if I get sequestered, that become issues around month end, quarter end. Those are always tough times. But I just feel like everybody has those commitments, work commitments, that doesn't make it a bigger deal just because that we don't know.
Okay, well, I appreciate that. With that in mind, then, you do believe you, if required to serve here, would be able to do it and give this your full time and attention if that was the requirement and you were selected?
Yes, I do.
Okay, thank you for your responses on that. With that, if council has any further questions, I'll just allow that in the section of voir dire, and we'll pass over remaining for hardship questions and move on. The next matter we're going to discuss relates to your potential knowledge of the case. You have heard a summary of the charges made in the amended indictment. Other than what I have told you, do you know anything about this case, either through your own personal knowledge, by discussion with anyone else, from anything you've read or seen in the internet, newspaper, television, radio, noting this is a highly publicized case, so many jurors have heard of the case. And if you have, we will discuss that. And again, the details of that will be discussed individually with you, so don't bring up any facts. But if of these remaining jurors, if you have knowledge of this case, meaning more than just what you heard described by the court, would you please raise your red cards now? Okay, so we've got most of the jurors here, and if you'll keep those up for a minute, I'll get these all noted as well as counsel. Okay, thank you. We are going to move on. We'll note that and discuss that information with you individually as you're brought back in once we conclude the group questioning here. Next issue I want to bring up is, as it relates to the charges in this case, I've read to you more than once now what the charges are, but this case has charges involving murder, conspiracy, and insurance fraud. Is there anything about just the nature of those charges or the subject matter of the case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? Okay, no one affirmatively answered that. I'm going to next ask some questions that might seem very obvious based on your questionnaires, but I'm required to go through these on some Idaho statutory authority to make sure there's no connection between you and any participants of this case. So next question, are any of you related by blood or marriage to the defendant, or do you know him, Mr. Daybell, from any kind of business or social relationship? All right, no one answered yes. I'll next ask about any legal relationship you may have with participants here. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you and any of the attorneys here today? No one affirmatively answered that. Are any of you a party in any civil action, civil lawsuit against the defendant, Mr. Daybell? No response to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the 4 prosecuting attorneys that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship, previous or current, with Mr. Pryor or his law firm? No one responded to that. Do any of you believe you've already formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? And if so, please raise your red card if you already have an opinion of guilt. All right, we've got one, juror 1057. And we will discuss that with you individually, 1004 and 951. And then we'll discuss that with you individually. Somewhat related here, do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? No response to that. Are any of you unwilling to follow the court's instructions to you as the jury as to the law that you must apply in determining this case? No one responded to that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? No one responded to that, and I'll note we will ask you further questions individually that may cover that topic as it relates to the state's notice of intent to seek death penalty in this case. Are any of you, as selected as a juror in this case, unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, no one said yes to that. A final catch-all question here. Do any of you have any other reason why you could not give this case your undivided attention and render a fair and impartial verdict? No one answered that question either. At this time, then, that concludes the court's portion of voir dire. I'll now allow the state to have its voir dire followed by the defense is going to be doing voir dire for this group today.
I will be running.
All right, thank you, Ms. White. If you'd like to go ahead and question the jurors, you may do so.
Thank you. And thank you, ladies and gentlemen, for being back here this morning. I know this one's been a bit of a longer process, and you were all here last week to fill out some questionnaires. So we appreciate you hanging in there with us while we go through this. The reason that we go through this whole process is we want to do our best to ensure that both the defendant, Chad Daybell, and the state get a fair trial. And so as we go through questions today, that's what we're looking at. That's why we're asking you questions. So as we go through this, I don't mean to put anyone on the hot spot or in the hot seat, so I hope no one feels that way, but we may ask you some questions as we go through this. If I use the term brutal honesty, what comes to mind? Juror 1048. If I use the term brutal honesty, what does that make you think of?
It makes me think of just telling the absolute truth. No falsehoods and lies, just straight facts and straight truth.
Thank you. And juror 909?
Just that you would be completely honest regardless of how it might make the other person feel.
Thank you for that. And the reason I bring that up is as you sit here today and answer these questions, we're going to ask you to be brutally honest. And so it's part of the process today. And then if selected as a juror, at some point, you're going to go back with your fellow jurors when the court instruction says you can start talking about the evidence and what you've heard, and you're going to start having discussions. And we want to make sure that anyone here can be brutally honest both today through this process and also when you go back into that group setting, that you can be brutally honest with each other and speak up. So that's why we talk about that. And I don't know if any of you know, to me, when I think of brutal honesty, one of my nieces comes to mind. So she was my first niece, and as this little girl, I quickly learned if I wanted to know the truth about something, I could go to her. If I wanted to really know how my hair looked that day or how an outfit looked, she did not hold back. She let me know. And I think we probably all know somebody like that whether it's a little kid or the filter, and I don't know if all of you know someone like that that's kind of your go-to to get that straight answer. And juror 1057, I think I saw you nod at one point. Do you have someone like that in your life that will just give you that straight answer? The judge talked to you about the subject matter of this case, and we didn't have anyone raise their hand that they couldn't sit on this. As you're aware, this case does deal with several counts of conspiracy to commit first-degree murder, as well as several counts of first-degree murder. There was a question on that questionnaire. Some of the images that you may see in this case may be graphic, they may be disturbing. It's normal and it's fine to be disturbed by these images, but I just want to check, is there anybody on the panel today that have seen images of, say, children, and maybe not the best images, graphic images, disturbing images? Is that going to cause anyone here concern that they couldn't be fair and impartial? Juror 1057. Let's talk a little bit about that.
it wasn't children, but my brother-in-law caught on fire and I put him out. And it's been a long time, and after filling out this and being here, more of those thoughts come to my mind
Of what you saw that day?
and smelled.
So in your mind, if you were, and that's a fair answer, and so not trying to put you on the hot spot, but just asking a few more questions. For you, if you were to see images, would you be able to set aside any thoughts of your brother-in-law and be able to just look at the images and give them the weight you think they're due in relation to any other evidence presented?
I think I could.
Do you think it would be so upsetting that it would cause you any kind of physical or mental anguish to the point that you couldn't be fair and impartial?
I don't know if I can honestly answer that, but I do know that I've been having trouble sleeping.
And when you say trouble sleeping, did that start, do you mean since you've been selected to potentially be a juror?
Yes.
And do you feel that's impacting your life in such a way that it would affect your ability to sit as a juror in this case?
I would hope not.
Thank you for your honesty. When I talk about brutal honesty, that's exactly what I'm talking about. Has everyone here flown on a plane before? I see, I think everyone nodded yes. So when you get on the plane, you probably recall at some point they kind of tell you, hey, sit back or lay back, enjoy the flight. We're gonna arrive at our destination at such and such time. If instead of getting that announcement, the pilot told you, hey, so I'm gonna try to land the plane. I think we'll get there at this time and hopefully we land. Would you feel comfortable staying on that plane? I see a few people didn't respond completely. I saw a lot of shaking of the head. Juror 752, would you feel comfortable staying on that plane?
Not knowing, I like to know where I'm going, and if there's uncertainty, I'm gonna be questioning it, trying to see if it gets answers. Like, I don't want to just be blindly and just following. I'd like to see what's going on.
And I appreciate that. Juror 922, how about you?
I prefer my pilot to be competent and confident, I would say.
And I think those are both very fair answers. So if you have the choice and you could get on a plane where the pilot says, I can for sure land this plane, and the other plane, the pilot says, I might be able to land it, which plane are you getting on? And I'll ask Juror 951, which plane would you get on out of those two?
The one the pilot is confident of getting to our destination.
And I know that might seem like an odd analogy, but when we ask you to sit here, and this goes back to the brutal honesty, because the defendant, Chad Daybell, is entitled to a fair trial, as is the state, we want to make sure that we have jurors that can say, you know what, I can sit here, I can weigh the evidence, I can be fair and impartial, and essentially I can land this plane. I can do what's being asked of me. And so as we go through these questions too, we want you thinking of that. Can you keep an open mind and weigh the evidence and give it the weight that it's due? Because that would be your job as the jurors here. So I have a little boy, and in the mornings when he wakes up, if I ask him, what do you want for breakfast? 9 times out of 10, it's cheesy eggs. But his cheesy eggs are made a certain way. We have to do the eggs, we have the cheese, we have the milk, and we have the salt and pepper. And honestly, he likes extra cheese. So that's his recipe for the cheesy eggs that he wants me to make. And if I vary it, he's not necessarily happy. But do any of you have that experience where, whether it's a kid or someone in your life, there's some kind of a recipe that they like made just a certain way? That's just how they like it. And Juror 1004, have you had that experience?
Definitely similar with, 3 kids now that are getting older, but yeah, my 3-year-old, she definitely, she'll eat just about anything, but she's very particular about certain things.
And Juror 909, how about you?
Mainly with kids, but I don't know that I ever had anything that was super specific. It was either I don't want a kid or do you want a kid.
Or I like it. And if you're around someone like that and you're given this recipe, I think sometimes it's easy to say, if I changed it this way, if I added this, or if I took this out, or I made it just a little bit different, it would make more sense, or I would like it better. When you're sitting here today, and the judge did give you one jury instruction today, if you're selected, you're going to hear a lot of jury instructions as you go through this. And some of those jury instructions are also going to be instructions that contain the elements of the crime. So kind of like a recipe, the judge is going to lay out, the state has to prove these specific things. The state doesn't have to prove these other things, and the state has to prove all of them. And sometimes it's easy to look at those and think, well, this doesn't make a lot of sense. Why don't they have to prove this? Or maybe they shouldn't have to prove this. We have to make sure that you can follow that recipe or that jury instruction as given by the judge. Does anyone have concerns that you wouldn't be able to follow the instructions given by the judge, or that you'd be tempted to modify it? Anyone have that concern at all? Okay, I don't see anyone saying they have that concern. So with those, when we talk about the recipe and the instructions, as I said, the judge will lay out the elements. And sometimes it might not require an ingredient or an element that you think we should have to prove. When you're dealing with first degree, you would get a jury instruction, and it'll come from the court, but it will essentially talk about an individual had to be part of causing the death. But one of the elements isn't going to be that we have to prove the actual cause. So essentially, we have to prove that they were part of it or that they committed the murder, but we don't have to prove how they went about it. Does anyone have concerns with that, with following the court's instruction on that? So if the state was able to meet the burden of proving that they did it or they were part of it, of the murder, would anyone have concerns if the state didn't prove the actual cause of the murder, if that's not one of the ingredients? I don't see anyone saying yes to that. And again, you previously heard the judge give an instruction regarding conspiracy and talking about it being an agreement by 2 or more persons to commit a crime. So I'll tell you, I have some older brothers, and 2 of them were pretty close in age. And so my mom will tell stories about the 2 of them because they would get into shenanigans together. And the 2 of them, one of the things that they would do is the older brother and the younger brother would get together and they'd come up with a plan. And oftentimes the older brother wanted the younger one to carry it out first. So they came up with a plan to jump out of the barn door. So as part of this, they come up with a plan, they go into the barn together, they climb the stairs, and the younger brother jumps out. Well, he gets hurt. So the older brother doesn't follow. But they both had talked about going to do it. They both had the intention. So ultimately, they both were involved in that. So when we talk about a conspiracy and an agreement by 2 persons to commit a crime, you'll get instructions regarding the agreement and what qualifies as an agreement and what an agreement actually is. And again, that will come from the court. But it will talk about that only one person in that agreement has to do something that is referred to as an overt act. So only one person has to do some act to further that. Does anyone have a problem? Because let me back up a little bit. You were also instructed by the court that there are co-conspirators that you may hear about, and you're not to worry about what's going on with them. But what you will hear evidence is of some of the actions or the allegations that the state has, and you'll hear evidence regarding those actions of the other co-conspirators. Does anyone have a problem knowing there's an agreement and only one person has to do an act in furtherance? Does anyone have concerns that person A may not have done the act in furtherance of the conspiracy and person B did? Does anyone have a problem then essentially holding person A still accountable? So like the brothers planned, both of them climb up the stairs, but only one jumps out the window. But they both planned it. They both were going to do it. Anyone have concerns about that at all? Thank you so much for your time this morning. I have no further questions.
All right, thank you, Ms. Wade. Mr. Pryor, you can conduct voir dire for the defense.
Good morning, ladies and gentlemen. Voice distracted. I don't know if that's okay. I need to do this. I'm here today to ask you a number of questions. And I don't want you to infer from any of those questions that there's a right or wrong answer. What we're here today is just talk and get to know each other and sort of get feelings about how we feel about a variety of topics. And again, there isn't any right or wrong answer. But before we start that, I do want to ask you a question. And I brought this up with a couple of the other hearing folks. Many years ago, when I was a much younger man and much skinnier, I was in college and I was having to do jury service, much like what you folks are doing. And the attorney at the time, and I remember this, and maybe it was the reason I became a lawyer, I don't know, had an impact. Because the attorney stood there and said, is there anybody who just doesn't want to be here today? And I thought that was a very interesting question. And I didn't think long, and I raised my hand. Now, I'm not trying to dodge my responsibility, my civic responsibility to be a juror. That's not really what I was doing, because I appreciate that. And we have a law enforcement officer who's sworn to uphold the law and to do his best to follow the rules. And yet, I can tell by the distress of having to be here, and I can see it on his face. There's concern. And so I really want all of you, and the state talks about brutally honest. I'm going to touch on that a little bit later, but I need all of you to be honest with me. And you're not going to hurt my feelings. I can't speak for the folks over here, but I know that no one's going to take offense to that, because this is a serious case. And it's a complicated case. And we need all of your attention. We need it to be focused on this. And it's not going to be imputed to you that you're not doing your civic duty. And it's not going to be suggested that you aren't, faithful to our country or all of those things that are at least important to me, but important to all of us. That's not the case here. But in all seriousness, I guess we have to really be honest about that. I'm not going to use the words brutally. I find that a strange adjective to attach to a statement of honesty, but that's their issue, I guess. But again, I'm going to ask this. Is there anybody who just feels that what's going on in their personal life is so profound, so complicated, they just don't think they could, in all reality, do this very complicated job? Hold up your cards, please, if you feel that way. Nobody. We're here today, and you've heard the allegations from the judge. You've heard him what he's had to say about the charges that are against Mr. Daybell. Is there anybody here who, at the present time, based on what the charges are alleged, believes that Mr. Daybell is guilty right now? At the present time that he's guilty right now. 1057? Okay, and 1004. And I guess I'll inquire, 1057, is there any chance that you're going to be able to change your mind in that regard, or are you pretty firm in your belief in this?
I will definitely weigh the evidence.
Okay, okay.
You asked if I felt that, and I answered correctly.
Okay.
I am honest.
Okay. Okay. And 1004, law enforcement officer, and I can understand.
I definitely would want to weigh the evidence.
Would weigh the evidence. Okay, all right, thank you. Is there anybody here who can't sit for long periods of time, other than me? Is there anybody who is unable to sit, or because of any kind of health concerns, you're not able to, okay, 922. You have some concerns about sitting for long periods of time?
I know I'm young, but I have had a kidney stone in the past. I'm already sitting here wishing for a bathroom break, I'm not gonna lie. Sometimes it's just, health concerns, it's difficult.
Do you need to take, and I don't want to announce this, but do we need to take a break right now?
Not on my account only, but, if there's other people who need it.
Judge, do you think you want to take a short break?
I do, actually. Looking at the time, sometimes we lose track of how long these jurors have been captive before we get breaks and other court staffs. So it is late in the morning. Let's go ahead and take our mid-morning recess.
Judge, I'm joining you.
Okay, and we'll conclude then with additional defense for Dyer, but we'll go ahead and take a mid-morning recess at this time and try to come back in about 20 minutes.
All right, please. Microphone.